Article 69 Rights Canon 1786 A valid right is a fictional concept under positive law, whereby a person has certain control, benefit of use or privilege of particular property. A right, also known as right of use, is equivalent to property. Canon 1787 as a valid right is equivalent to property. It presupposes the existence of property, which implies the existence of a trust relationship and a valid trust deed defining the nature and limits of the right for the beneficiary. Canon 1788 In the absence of property, a right cannot exist in reality. Canon 1789 There exists no such thing as a natural right under natural law except those rights associated with divine trusts and true trusts in accordance with Pactum de Singularis Caelum. Canon 1790 There exists in reality no such thing as legal rights, civil rights or statutory rights, except those rights eventually granted through the existence of a superior trust to a juridic person under its statutes and limits of authority. Article 70 Claims Canon 1791 A claim, also known as a cause of action, is by ancient definition a witnessed formal oral protest and pronouncement of one or more rights, usually supported by one or more sealed and notarized documents. Canon 1792 The claim is the vocalization of a formal protest and pronouncement itself. Any associated documents are an affirmation, statement or some evidence dependent upon its perfection. Taken together they may correctly be called a statement of claim or an affirmation of claim. Canon 1793 A claim can be satisfied only through rebuttal by counter-affidavit point for point, resolution by jury, or payment. Canon 1794 If the plaintiff does not prove his case, the defendant is absolved. Canon 1795 A presumption of a claim in accordance with these canons will stand good until the contrary is proved. Canon 1796 The validity of a claim is the validity of the oral argument, constituting two main parts. Firstly, the formal protest of a challenge of rights also known as the wrong, and secondly the reassertion of such rights or pronouncement of new rights also known as the remedy. Canon 1797 It is insufficient for any claim to vocalize a wrong without a valid remedy. Similarly, no remedy has validity without first vocalizing a wrong. Canon 1798 Documents alone without any evidence of the vocalized claim can never be considered a valid claim. However, documents may be presented first to pronounce the intention to claim at some appointed time and place before a competent authority and witnesses. Canon 1799 Form of action is immaterial to the validity and substance of a claim unless by consent a person agrees to hear their claim according to the normal rules of form and action of a particular society. Canon 1800 Any juridic person or court that permits the resolution of claims and counterclaims merely by documents without either the original and subsequent claims being vocalized is in grave breach of a most ancient and fundamental principle of law. Canon 1801 When in accordance with these canons, a person who is first in time has the prior right of claim. Article 71 Title Canon 1802 A title is both a valid inscription or entry into the asset register of a trust and a certificate or notice of proof of such entry and therefore claim of right of ownership. The word title is derived from the Latin word titulus meaning inscription, label and notice, of entry, into a tabulae with the Latin word tabulae literally meaning register. It was most commonly used in the context of a register of slaves. The Latin word for a registrar is tabularius. Canon 1803 The creation of title occurs upon the valid entry of the claimed property into the asset register of the trust by the recording of a minimal set of information about the property now also defined as an asset. This minimal information includes I. A unique identifying number also called the unique register number, and 2. A name for the property, and 3. The day of entry into their register, and 4. The grantor, provider of the asset, and v. The custodian of the asset, and vi. The value of the asset. Canon 1804 Two main forms of title for the same property may exist in the asset register of a trust: legal title and equitable title. Canon 1805 Legal title refers to rights of ownership, usually held by the trustee of the trust. Canon 1806 Equitable title refers to the rights of use, usually held by the beneficiary. leaseholder, tenant of property of the trust. While the word owner is used with equitable title, it merely refers to the title and not the property of the trust. Canon 1807 title is distinct from possession, being a right that usually accompanies ownership but is not necessarily sufficient to prove it. Canon 1808 title formed under an estate never contains rights of real property but merely rights of real estate, as even the first estate must always by definition belong to a parent trust. Article 72 Succession Canon 1809 The creation of valid form by succession is when there exists a valid argument and proof of a succession of authority from a recognized source of power to the present form from which an object is created. Canon 1810 Creation of valid form through succession is a fundamental principle to the creation of valid form in relation to location form and ultimately valid land title. The absence of valid succession of survey from the absolute to any cadastre location invalidates any claimed location form and therefore its ability to be lawfully conveyed into a superior trust. Canon 1811 Creation of valid form through succession is a fundamental principle to the creation of valid form in relation to all ecclesiastical law, custom and ritual in that the absence of valid succession between the divine and the form from which an ecclesiastical form is created renders such claims invalid. Canon 1812 In accordance with proof of divine will, divine law, natural law, the seven sacred pronouncements of Euchadia and sacred covenant pactum de singularis caelum, the Roman cult, also known as the Vatican, also known as the Roman Catholic Church, is without valid apostolic succession. Therefore all ecclesiastical form and ritual of the Roman cult is invalid and without spiritual or supernatural authority. Canon 1813 In accordance with proof of divine will, divine law, natural law, the seven sacred pronouncements of Euchadia and sacred covenant pactum de singularis caelum, Talmudic law and rabbinical succession is without valid succession. Therefore all ecclesiastical form and ritual of Talmudic rabbi is invalid and without spiritual or supernatural authority. Canon 1814 In accordance with proof of divine will, divine law, natural law, all valid apostolic succession, spiritual and supernatural authority rests solely in those offices defined by the sacred covenant pactum de singularis caelum. Article 73 Occupation Canon 1815 Occupation is the act, process and intentional condition of possessing and existing at a physical place. Canon 1816 A person cannot occupy a place when they have no intention of being there. On wishing to occupy it, the proof of intention of occupation is the presentment of a valid claim. Canon 1817 A place occupied by force affords no rights and all obligations to the occupier. Canon 1818 Occupation does not imply any rights towards ownership unless it is done peacefully and accompanied by a valid claim. Article 74 Possession Canon 1819 Possession is the intentional act and fact of occupation, use, employment or effective control of a form. Possession is distinct from ownership in that a person who possesses a form may have no rightful claim or title. Canon 1820 A person does not possess a form unless it is their intention to do so. Therefore the actions surrounding the control and use of a form prove intention. Canon 1821 Possession that is considered lawful is called lawful possession. Canon 1822 Possession automatically presumes the tacit acceptance of certain obligations, whether or not possession is ultimately considered lawful. A possessor of form is obliged to act as an honorable steward in the management of those possessions. Canon 1823 Possession automatically presumes the tacit acceptance of certain rights, whether or not possession is ultimately considered lawful. The degree to which presumed rights of use or title may be granted are conditional upon the nature of the form and any associated trust. Canon 1824 Any person who claims ultimate possession in contravention of these canons, also assumes full liability and obligations. If this person having unlawful possession then acts in a way contrary to honorable stewardship they therefore consent to forfeiting any right, claim or protection under any law to the role of trustee. Article 75 Heir Canon 1825 An heir is a beneficiary recognized by the higher estate to possess a prior right to a lesser estate, unless excluded by will. Canon 1826 In determining a rightful heir, it is tradition for the executors and administrators of higher estates to follow the relevant cultural principles of inheritance. Canon 1827. The concept of heir is equivalent to the concept of title of nobility. An heir is always a person with beneficial entitlement to an estate, also holding right of use of one or more honorifics denoting the size of the estate and therefore the standing of the heir. Thus a sovereign traditionally denotes the holding of the largest kind of estate, while titles of nobility such as earl, baron, lord indicate successively smaller estates within the estate of the sovereign. Canon 1828. Where a higher estate permits heirs, the general principle of inheritance means that the property, titles, debts and obligations of a lesser estate may be passed to the eldest next of kin upon the death of the decedent, excluding the existence of a will. This is usually called the line of succession and is of particular importance in those higher estates still permitting a sovereign heir. Canon 1829. Where a higher estate does not permit heirs and therefore title of nobility, the absence of a will does not mean that the lesser estate is automatically inherited by next of kin, but that the higher estate may reclaim all rights under intestate and determine what rights shall be awarded to any next of kin, if any. Estates such as the United States expressly forbid title of nobility and therefore heirs within their deed and will. Canon 1830. As an estate belongs to a testamentary trust under trust law, an heir can never also be an executor or administrator of the estate for which they are also a beneficiary. Canon 1831. The entitlements of property or rank of an heir is determined by two primary factors. The first being the limits of property within the estate, and secondly the conditions and limits of the wills of higher estates to which the lesser estate belongs. Canon 1832. A will can never name an heir, only beneficiaries. In a higher estate that permits the existence of heirs, the existence of a will implies the disenfranchisement of one or more rights to an heir. Canon 1833. The heirs are words describing the extent or quality of the estate conveyed and not words designating the persons who are taking it. Canon 1834. When a person takes as heir at law, they do so by descent, but when he acquires title by his own act of agreement, he is a purchaser. Canon 1835. An heir always remains a beneficiary with any rights of property limited by the executors and administrators of the higher estate. Canon 1836. A person who murders another to obtain the status of heir is automatically rendered ineligible to succeed, regardless of any clause, term or caveat in any will or statute to the contrary. Article 76. Use. Canon 1837. Use is a custom or skill in the employ of a right for some benefit. Hence, the ancient principle right of use. Right of use is equivalent to property. Canon 1838. The use of an object or concept assumes possession. However, the questions of lawful possession and ownership are distinct from use. Canon 1839. A person who does not use a form over an accepted period of time, consents to forfeit those rights of use dependent on continuous use to the extent that such rights are agreed prior to the granting of such property by deed or title. Canon 1840. A person who takes lawful possession of a form and uses it over an accepted period of time, assumes those rights of use implied by such use, whether or not such rights have yet been formalized by deed or title. Article 77. Owner. Canon 1841. An owner is a person who holds the rightful claim to a form or title to property. As a person is a fiction, it cannot own objects and concepts, only other fictions in accordance with positive law. Canon 1842. Natural law. Objects and concepts cannot own one another, only themselves. The divine creator, also known as unique collective awareness, is the only true owner of objects and concepts. Men and women may claim right of use of objects and concepts by succession of divine rights, beginning with the legitimate trustees and administrators on behalf of the divine. Canon 1843. When original form owing its existence to the rightful claim of ownership of the divine creator is lawfully conveyed into trust, this is called realty, or real property, representing the highest right of use above all other claims of right and title. Canon 1844. In accordance with the will of the divine creator, the sacred covenant pactum de singularis caelum and the seven sacred pronouncements of Eucadia, all objects, concepts and all awareness are lawfully expressed into the trust administered by the Society of One Heaven for the benefit of all men, women, higher order beings, animals and life forms living and deceased now and forevermore. Canon 1845. In accordance with these canons, the Sacred Covenant Pactum de Singularis Celum and the 7 Sacred Pronouncements of Ucadia, any and all claims of ownership, conveyance, trust that are not in accord with these canons and the will of the divine creator are henceforth null, void from the beginning, consistent with the notice of unlawful conveyance. Article 78 Holder Canon 1846. A holder is a fictional concept whereby a person who possesses a document of an original instrument or facsimile is presumed to consent as surety to any associated obligations implied by the instrument, and therefore abide by the rules by which the instrument was issued, unless such surety is otherwise qualified. Canon 1847 When the rightful owner of certain property is also a holder of an instrument, then such possession of the document also represents their proof of ownership, consent and agreement to the validity of the rules by which the instrument was issued, as well as surety to any associated obligations, without physical need to demonstrate possession. Canon 1848 A person who is a holder of an instrument representing rights and obligations to certain property does not mean they are the rightful owner of the property, but consent to act as surety and abide by the rules of its issue. Canon 1849 The issue or record of issuing a document to a person does not imply a person is a holder. Nor does the presence of a particular document in close proximity to a person mean they are a holder. It is only when a person touches and holds a document in the presence of others do they become a holder. Canon 1850 The presumption of surety of a holder cannot be proven in law until a person confirms in the presence of at least two witnesses they are the holder. The absence of disclosure and knowledge to a holder of the obligations for which they have consented constitutes an act of deception and fraud. Canon 1851 It is immaterial whether a person holds an original or a facsimile of an instrument to be a holder. Canon 1852 As a holder implies acceptance of all associated obligations. A person has the right to qualify their consent by claiming to be only a holder in due course. A holder in due course is a holder that accepts their surety and consent for any obligations and performance due over the time an instrument is in their possession, but rejects any implied consent for surety for any potential misdeeds or errors by one or more previous holders. Canon 1853 A person that does not affirm their position as a holder in due course is assumed to accept the full obligations, responsibilities as well as any rights if owner of the property. Canon 1854 The assertion of a person to be a holder in due course has no effect in diminishing any acceptance and surety of obligations and performance due during their time as holder. Nor does the assertion have any effect if the person is the first holder of the instrument and user of the property. Canon 1855 A person who asserts their right to be known as a holder in due course cannot be lawfully held liable for the misdeeds of previous holders. However, as the person is still a holder, they continue to consent and agree to the validity of the rules by which the instrument was issued. Canon 1856 A person who does not physically hold or possess an instrument or who openly rejects consent as surety in the presence of two or more witnesses cannot be held liable for any associated obligations and performance implied by the particular instrument alone, nor any conditions of the rules by which the instrument was issued. Canon 1857 The rejection of consent as holder or the absence of possession of an instrument does not excuse the obligations and performance of a person as a lawful owner or user of the particular property. Canon 1858 A lawful owner, or holder that rejects the rules by which the instrument they hold was issued is by definition in dishonor and delinquent to the terms by which such an instrument is held and used. Article 79 Realty Canon 1859 Realty or real property represents the highest right of use above all other claims of right and title. It is formed when original form owing its existence to the rightful claim of ownership of the divine creator is lawfully conveyed into a superior trust. Canon 1860 Realty can only exist in one superior trust at any time and is dependent upon the existence of an associated true trust holding true objects and concepts as well as an associated divine trust. Realty can never exist in an inferior trust. Canon 1861 In accordance with the will of the divine creator, the Sacred Covenant Pactum de Singularis Celum and the 7 Sacred Pronouncements of Ucadia, all realty is already lawfully expressed into superior trusts administered by Eucadian societies for the benefit of all persons. Canon 1862 A member of one heaven, in possession of their unique membership number is lawfully permitted to express into existence a superior trust for the temporary administration of realty providing the following specific words are followed and a permanent superior trust is registered with one heaven within 90 days. The specific words permitted to create a temporary superior trust are, we, the divine immortal spirit, expressed in trust to the living flesh are known as, first name, of the clan name. Canon 1863 excluding deliberate obstruction, the failure of a member to register a superior trust with one heaven within 90 days of expressing its creation shall cause the trust to be closed and any claimed realty to be lawfully returned to the society, with the member accepting full liability for any debts, obligations held by the closed trust. Canon 1864 a man or woman who has not redeemed their member number of one heaven is not permitted to express into existence a superior trust. Such an expression whether orally or written is automatically null and void from the beginning. Canon 1865 any man or woman who unlawfully attempts to create one or more superior trusts automatically assumes the full liability, debts and obligations of all associated persons as sole surety. Canon 1866 in accordance with these canons, the Sacred Covenant Pactum de Singularis Caelum and the seven sacred pronouncements of Eucadia, any and all claims of realty, real property, that are not in accord with these canons and the will of the divine creator are henceforth null, void from the beginning. Article 80 Property Canon 1867 Property is any fictional right of use expressed into a trust relationship with other forms whereby there exists a claimed form of ownership, form of trustees administering the form as property and forms of beneficiaries. Hence property is the rights of an owner to use the form, never ownership of the object or concept itself. Canon 1868 Property is equivalent to rights of use of an object or concept, not rights of ownership of an object or concept. Canon 1869 Realty or real property can only exist in one superior trust at any one time. However, lesser forms of property derived from real property in superior trust may be conveyed and exchanged. Canon 1870 Property cannot exist in reality without an owner, at least one trustee and at least one beneficiary. Form not expressed into trust by some lawful conveyance does not exist in reality as property. Canon 1871 All valid property rights are derived from the trusts expressed in accordance with the property rights promulgated through the original Eucadian pronouncements and Sacred Covenant Pactum de Singularis Caelum. Canon 1872 The ownership rights of property cannot exceed the ownership rights of the original owner that conveyed the form into the first trust in the beginning. Canon 1873 By definition, any claimed property ownership that contravenes the seven Eucadian pronouncements and Sacred Covenant Pactum de Singularis Caelum is therefore void from the beginning. Canon 1874 Any person who claims ultimate possession and ownership of property that contravenes these canons assumes the full liability of any and all associated debts, obligations and injury associated with this property, even if others have consented as surety. Canon 1875 When anyone references, writes or speaks of property laws, or laws of property, it shall mean these canons and no other. Article 81 Fealty Canon 1876 Fealty is loyalty and fidelity to the obligations of honorable stewardship accepted with rights of use otherwise known as property. Canon 1877 Obligation of the trustee as executor and surety is attached to the land therefore the use of the land as property contains these obligations which are the fealty owed by the beneficiary as an owner of uses, property. Canon 1878 The degree to which a trustee may choose to transfer these obligations into the form of fealty through a deed and title is the decision of the trustee, subject to the deed of the trust. Canon 1879 Once the obligations of trustee are transferred into fealty to a beneficiary through deed or title, the beneficiary agrees to act as owner of uses and surety for some or all of the obligations implied by such fealty. These obligations may include such demands as the payment of rent, taxes, duties and other duties. Canon 1880 When a person agrees to act as owner of uses and surety for some or all of the obligations of the trustee, then the trustee is immune from any claims of surety and damage unless the person lawfully surrenders their rights and obligations, in which case all obligations under fealty return to the trustee and all debts and liabilities return to the grantor/settler/owner. Canon 1881. The failure of an owner of uses to perform their duties under fealty usually constitutes a breach of the deed or title granting property to them. Therefore, a trustee usually has the right to demand the return of any associated property and the relinquishment of any possession of any associated objects and concepts held in realty. Article 82. Beneficiary. Canon 1882. Beneficiary applies to two different types of relationships: one who holds a benefice of a trust, or one who holds a benefit of an estate. Canon 1883. A benefice is a gift granted by trust under deed and title, including both rights and obligations to certain property. Canon 1884. A benefit is a gift offered and elected to be accepted by a state under the terms of the deed and will, including both rights and obligations to certain property. A beneficiary under estate may be a beneficiary or assessee trust for whose benefit the property is held by a trustee. Canon 1885. Unlike a benefit requires the consent of the beneficiary. Therefore, a benefit cannot be conferred on one who is unwilling to receive it. Canon 1886. One who elects to accept a benefit is bound to give effect to all the provisions of the deed and will of estate by which it is granted and perform any burdens imposed therein, including the renunciation of any inconsistent rights or claims. Canon 1887. One who is offered a benefit must choose between either accepting such benefit or asserting some other claim against the testator's estate. Canon 1888. A beneficiary of a benefit that remains in the possession of money, property or some other benefit extended to them by the deed and will of the estate automatically forms an election in favor of the will, unless it is demonstrated that such acceptance is in ignorance of the operation of the will. Canon 1889. An unconditional voluntary election to take under or against a will, made with knowledge of the facts and of the rights of the person compelled to elect and not induced by fraud or undue influence, may not be revoked or set aside. Canon 1890. Money, property or some other benefit accepted by the beneficiary in ignorance of the will, its obligations, does not indicate a making of a binding election in favor of the will, but fraud on behalf of the executors or administrators of the estate. Canon 1891. The offer of a benefit to a beneficiary without disclosing such a benefit is a condition of operation of a will of an estate, is a fraud and deception voiding any obligations upon the beneficiary. Article 83. Tenancy. Canon 1892. Tenancy is a fictional term that defines the occupancy of property under lease agreement. Hence, a tenant is an occupier of leasehold. Canon 1893. Tenancy means both the period of occupancy as well as the property occupied by the tenant. Canon 1894. Under a lease, also known as a tenancy, a tenant is obliged to pay the owner of the property some form of fee for its use or compensation. The most common term for the fee paid by a tenant for use of property is rent, while the most common term used for compensation from use is tax. Canon 1895. A borrower, also known as a mortgager of a mortgage, is a tenant, with the bank or financial institution as their landlord and the rent being the interest component of their loan. Canon 1896. A bank or financial institution of a mortgage as lender and landlord to the borrower is itself a tenant of the relevant county or state as the higher landlord, with the rent payment due in the form of tax. Canon 1897. When a financial institution does not pay the rent it owes to the higher landlord but permits its tenant to pay rent twice, then this is a fundamental fraud and corruption of the principles of leasehold and performance of duties. Canon 1898. While a tenant may be guilty of breach of contract in failing to perform their obligations, by the most ancient of principles of law, a landlord is not permitted to evict a tenant until they are afforded an opportunity to repair the breach. Canon 1899. A failure by any inferior Roman court to provide clear instruction to a tenant on how to repair a breach of contract is a serious fraud and injury against all contract law and tantamount to consenting that inferior Roman law of agreements no longer applies and is null and void.